I do. Oh, so as far as this matters, yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes.
Well, the charged alleged conduct in the police report, as far as that report, which we have not had any substantive hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have stood mute on that matter.
Screenshots.
Yeah, and we do. I mean, we are gathering discovery on the matter and concerns related to bond about Ms. McDowell being close to the complaining witness. I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell.
I got her moved.
Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell has there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. You're
saying the bond I set was excessive?
Well, at present, given the current circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And, she has already been in custody for 15 days. The final matter is, she has, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court.
This is the classic bond tug of war. Defense leans on distance, tether, and hardship. But hardship doesn't erase risk. Judges weigh two things: appearance in court and public safety. If either looks shaky, the bar gets higher fast.
For her to be released, but if the court would consider, her.
Where are the other two children?
My kids were left at home, attended for 2.5 weeks, sir, and I literally moved my kids to Detroit to my mom. They are safe now, and I did sign my rights over, sir. But my children were left home, attended for 2.5 weeks. I sent cash up money to them.
This is Ms. McDowell. I don't think we want to address anything with the children right now, other than the fact that they're residing with their grandmother.
I got the move. I just want you to know that, sir.
And Ms. McDowell, all 3 children are living with the grandmother.
And I've been working from my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just.
And I've never been accused of anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir. And that is taken care of. And it was just and that was the
Ms. McDowell, I think if you can just hold off on saying, I think we'll address anything.
I just wanted to speak
Yes.
up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I did know that they were home by themselves. And it just was discovered. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all, Your Honor.
Your Honor, if the court's familiar with this case, I'm not going to re-exhaust the.
Her voice shakes because the stakes are real. Kids, job, a home she fears is being vandalized. Pain can be true and still not outweigh safety concerns. Both can exist at once, and that's exactly why bond hearings feel brutal.
That we filed. The only thing that I see that's changed since last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is being stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police. She had to text a friend to call police because she was so afraid. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case, and I believe in our bond form, our original request was 100,000, so 50,000 as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may.
This is where the case snaps into focus. Alleged stabbing requiring stitches and a death threat to a child. Even before trial, these facts, if credible, drive bond conditions. You can feel the room tense when stitches hits the record.
Address that. There is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case. Well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say I don't believe. I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case, with no allegations that she has violated her.
Telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should.
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered an octave.
I understand all of that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact, in addition to the fact that there would be a GPS tether as part of her bond conditions.
Yeah.
Defense pushes due process. A police report isn't a conviction. Smart angle. But bond is about risk right now, not guilt beyond a reasonable doubt. Distance plus GPS can help, but judges won't ignore violent allegations involving a minor.
I did also want to make the record clear. She does have a previous conviction for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOP with another domestic relationship. So I mean, I do have concerns. She does have an assault history, and given this case, I'm concerned that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She got a DV conviction. Motion for bond reduction is denied. Bond will continue.
Prior DV plus larceny plus a pending DV case? That history undercuts the no violence claim. The denial was almost inevitable. For editors, hold on her reaction. Micro expressions matter here.
You've been here every time for you. All right.
Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report that is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people? All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'll be asking this might be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond for him on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see this prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks, and he's asking for potential release.
I would ask that bond remain as currently set. I appreciate Mr. Feaster's advocacy on behalf of his client. I'm struck by the I think it was in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe. Candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger.
Nothing further, Judge.
All right. I am going to deny the defendant's request for bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters, and typically I can let Mr. Scott out of custody, may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week.
Scott's attorney runs the full mitigation playbook: meds, treatment, family, tether. The prosecutor answers with one word between the lines: dangerous. And the judge lands the point: I released you. A week later, new trouble. Trust spent is hard to buy back.
You kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way. And the prosecutor is saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I got to go see Slay today. They said if I do get released, they're going to follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. You know, it's my grandma. She's 70 years old, something like that. You know, what it happen if you keep me in here and then she just something
Mr.
happens?
Scott,
No, listen.
Mr. Scott, no, you listen.
You-
No, you listen.
but
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8. Now I have you involved in a crime that involves pointing a gun at another person. I'm done.
what do you mean?
Bond.
Listen, can you just let me
Motion for
judge?
bond reduction denied.
This is raw. Grief, addiction, and a plea for structure. He's not just asking for freedom, he's asking for guardrails. But no, you listen. Is the moment he loses the court. Judges hear pain every day, what they need is compliance. Tough to watch, necessary to show.
It never fails, it never ceases to amaze me, okay? He's got a warrant out of Hazel Park, warrant out of Southgate,
I had time for Hazel Park.
out of Bonia, warrant out of Taylor, another 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 one out of Taylor. He doesn't show up on this for 2 years and he wants to talk to me about suing cops. Do whatever you gotta do. I don't know who you think you are. You must be running the Pentagon at least. Shut him off, Lisa. We'll see you here in a couple weeks.
Procedural, but oddly dramatic. A rap sheet of misdates and fresh warrants. Then talk of suing cops. The judge's subtext. Show up first, then talk.
No, they were saying they wanted discovery.
Yeah,
This is not good news for you. Come on up. You tested positive for marijuana. What are your bonds in these cases? In 23 CR 905 and 907, ma'am, as you know, you are charged with the state jail felonies of forgery and fraudulent use of identifying information. And these are state jail felonies which carry with it up to 2 years in the state jail on each case. On your bonds, the first bond condition is do not commit a crime. That's the first bond condition of everybody's conditions on bond. You have tested positive for THC, tetrahydrocannabinol, marijuana. You have marijuana in your system. Thus, that is a crime of illegal possession of drugs. Her bonds are what?
10,000.
They are revoked. Now they are doubled to $20,000 each. Plus, you must have a drug patch as a condition of bond so that we will be testing you constantly to make sure that you don't fall on the bad side and continue to make mistakes here. You're looking at up to 4 years in confinement on these two cases. You've got to deal with these responsibly. And this is not responsible behavior by failing to follow your bond conditions. And most certainly, you have to avoid drugs. We will tell Mr. Dusler about this. I want this set here. Can you have a docket tomorrow? Is that correct or not? Yeah. All right. I'm gonna add it tomorrow because I'm looking at these cases and the circumstances, and she admits to the crime.
There's
So
supposed to be an affidavit because the situation was.
There were two co-defendants. One of them admitted it, and then at the last minute said that it was her idea.
Trying to look the
I spoke at Milton on February 10th. I spoke.
Since she was the
Yeah, but no, this isn't a debate. I'm going to read to you what the problem.
thing was his on a paper, but I'm telling you, like,
You're going to interrupt me?
no, I'm not.
You're taken into custody. You're going to interrupt me? That's not the way to handle it
sorry.
responsibly. That's not the way. This isn't a debate. This, hold on. The probable cause affidavit signed by the officer states he spoke with you on February 10th, provided a voluntary statement saying you're the one that picked up the identification cards outside of the gym and had the check in your possession. When confronted with the fact that the driver, the other person, confessed to signing the check, you told the policeman, told the officer, the driver only did that to protect you. So you admitted, you confessed to this crime. Now, the other one did too, but you were insisting she was wrong. She was covering for you. That's your fault. That doesn't look good. But there's a responsible way to handle this. Everybody makes mistakes who are in this room, who come in. Just fix the mistake properly. Be responsible. There are proper ways of handling it. And number one is work with your attorney. But number two is don't commit crimes while you're on bond. Don't ever commit a crime, but being around drugs, even if you're around them, you need to run. If it's marijuana, you know what it smells like, you run away because you are required, you can be tested at any time under the as all people on the bonds. Why you'd even get around it in the situation you're in is flirting with trouble. But we're going to put you back on the docket tomorrow to bring you up and see if get Mr. Dusler up here to talk to you about how this might be something that can be disposed of in your best interests. Okay, that's what we want to do. But you got to be honest and follow the rules. And those are the same things I got to do. And that's the way you fix a mistake. Everybody makes a mistake. Me, you, we all do. It's how you deal with it. That's really the test of your character. Are you a good person? Deal with it responsibly. Fix this. This is fixable. And that's why I'm bringing this thing back up tomorrow, that it might be able to get fixed tomorrow. Now, do you have private stuff that you need to get to your family or something? Because you're under arrest until you can post this bond and get a drug charge. And that's why it's going to probably not be tomorrow.
Big message. Clip 9. Different courtroom, same theme, bond is a contract. You test positive, you break it, bonds double, cuffs click. The affidavit readout matters. Admissions close doors. Editor note. If any personal data appears on screen, blur it. Keep the moral crystal clear. Fix mistakes the right way or the system will fix them for you.